Good morning, everybody. Welcome to Prime on this beautiful Friday morning. I'm Allison Muccio with the Boca Chamber, and I'm happy to have everybody with us. What I would love to do first is introduce Emily Lawless. She is with Allegiance Home Health. They are our sponsor, and they're the reason that we can do this program. So, Emily, are you there?
Yes, hello. Hi, I'm Emily Lawless, and I'm passionate about helping others. Growing up with a special needs brother, amongst other things, has taught me the importance of a helping hand. As a care coordinator with Allegiance Home Health, helping others is a daily occurrence for me. And so, Allegiance Home Health, we provide care in the home. We can offer nurses, therapists, and caregivers to assist and help bring fullness to life and help with recovery, or maybe a caregiver can help with like housekeeping, driving to doctor's appointments. Today I'm wearing red in support of Wear Red Day. You wear red clothes or accessories to show support and awareness for stroke disease and heart failure. So, heart disease. So if you know of anyone who is recovering from a stroke, Allegiance Home Health can provide a nurse, a speech therapist, maybe a private caregiver to help recovery, and they know the signs to help prevent another one. And so all of our caregivers are hired through us, and that's very important to us that they're our employees. And then Medicare actually rates off of patient satisfaction and outcomes. And so Allegiance Home Health is proud to be 5 out of 5 stars, which the Florida average is 3 stars and the Palm Beach average is 3.5. So if anyone ever needs our services, please feel welcome to reach out. We're located right next to the Chamber in Boca Raton, but we serve Broward County all the way up to Indian River County. So yes, I'm Emily Lawless, and I'm always here to help. Thank you. Allegiance Home Health.
Thanks, Emily. So now it is my pleasure to introduce Ellen, who is a Florida Bar Board Certified Labor and Employment Attorney and heads the Labor and Employment Practice at Assouline Berlow, with a focus on labor and employment law, counseling, and litigation. She has significant bench and jury trial experience and litigates cases in state and federal courts and represents clients at governmental agency proceedings. Ellen is a member of the Executive Committee of the South Palm Beach County Bar Association, is a past president of the South Palm Beach County chapter of the Florida Association for Women Lawyers, and serves on the Florida Bar's Labor and Employment Certification Committee. Ellen has been named a leader in the law by the Florida Association for Women Lawyers, a top attorney in Florida by the Wall Street Journal, and a Florida super lawyer by Thomson Reuters. And without further ado, I would like to introduce Ellen Leibovitch.
Thank you so much, Allison, and thank you so much, everybody, for braving the early morning on a Friday morning. I guess everyone's ready for the weekend, so we're excited to get up Friday morning to do a little learning. Probably no one's as energetic as Nancy Prophet, but that's okay. We'll get through this. You know, I love actually being on Zoom and doing these seminars because it's the only time that anyone has ever told me to unmute myself, because usually everyone tells me to just be quiet. But I'm happy to be here today, and we've got a pretty narrow topic, so I think it'll probably be easy for everyone to follow along. And what we're going to do is, if you have any questions, you can put them in the chat room. When we're finished with each slide, I'm going to say, does anyone have any questions before we go to the next slide? I think it's better to ask the questions as we go along, but of course, at the end, I'll be happy to take questions as well. So without further ado, in answer to the first question, can employers require employees to get the COVID-19 vaccine? Let's go to the next slide. The answer is yes. And this is one of those answers that is actually an unequivocal yes, not it depends. But I will tell you there are circumstances when people will be exempted from the vaccine. But according to the EEOC, employers in general can require employees to be vaccinated against COVID-19. Now, I know a lot of employers have been having their employees work from home, but they would like to resume in-office attendance. So this is really particularly applicable to employers who do want to resume in-person attendance, at least for the most part. So you can require your employees to be vaccinated against COVID-19. Now, the availability of the vaccine is another story, which we're not going to talk about today because everyone has read the news and everyone knows what's going on. But the good news is today, my husband, who actually works with elderly people and can be qualified as a healthcare provider, finally got an appointment for Monday at Publix. So it seems like the process is improving and that vaccine availability is going to be increasing pretty rapidly. Now, the EEOC has determined that a vaccine is not a medical examination under the Americans with Disabilities Act. And we're going to talk a little bit more about the Americans with Disabilities Act as we go along. But employers who actually are monitoring the vaccination process need to be careful that any vaccination related questions are in compliance with the Americans with Disabilities Act and related state and local laws. The questions need to be job related and consistent with business necessity and should not be overly personal in nature or anything not having to do with getting the vaccine. But that's only one way to administer the vaccine is through employer guidance. We're going to talk about other ways. Do we have any questions or can we move to the next slide? Okay, let's move to the next slide. So talking about administering the vaccine, there's 3 general ways for employers to require their employees to become vaccinated. The first is by off-site by third parties, for example, your CVS, your Publix. I know they're doing vaccines now at the South County Civic Center, wherever vaccines are offered currently or will be offered. That's third parties. Off-site by third parties who are hired by the employer to administer the vaccine to employees. That's when you've got an employer that wants to. There's one place where their employees are going to go, that they know that they're going to get an appointment, that they're going to get a follow-up appointment. That's an off-site third party hired by the hired by the employer to administer the vaccine. And the third method is having an appropriately licensed employee administer the vaccine on-site. That's not going to be applicable to most employers. That would probably only really be applicable to employers in the healthcare industry. Obviously, the first option is the easiest. Hiring a third party for the employer to make sure their employees are vaccinated is a little more expensive. And, quite frankly, at this point in time, I'm not even sure that it's viable given the vaccine shortage. Although, like I said, everything is changing day by day, and it seems like there's going to be more vaccines on the market, more availability, and hopefully we're not going to be having the long lines and the inability to get appointments in the near future. Like I said, option 3 is really most likely inapplicable to most employers. Any questions, or can we go to the next slide? Okay, let's go to the next slide. Now, employers, as I said before, that administer the vaccinations, they are required to keep any type of pre-screening questions related to providing the vaccine limited to anything that has to do with the vaccine only. Now, this may actually expose some personal health information, which may impact disability-related issues and perhaps accommodation. The key is that any questions asked by the employer in connection with providing the vaccine must be job-related and consistent with business necessity. So this means that any employers that do not have a reasonable belief that employees who do not answer the questions will pose a direct threat to their own safety or the health and safety of others. Basically, what this means is that if employees refuse to answer questions and therefore are not going to be willing to submit to the vaccine, the employer needs to consider whether that employee, by not having the vaccine, is presenting a direct threat to their own safety or the health and safety of others in the workplace. Does anyone have any questions, or we're going to go on and talk a little bit more about what direct threat means? Okay, let's go to the next slide. So I will tell you that the idea of direct threat generally is a very high bar. However, given the very scary, very contagious nature of this virus, I believe, although I cannot say for certain, that an employer seeking to prove that an employee who is not vaccinated can present a direct threat to the workplace is probably going to be easier. The issue becomes the duration of the risk. For example, if we reach herd immunity, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of the potential harm. I think all of those are pretty easy standards to meet as we stand right now. Again, direct threat is something that has to be assessed at the time. So what may be a direct threat today, which I think that it probably would be a direct threat if you have someone who, for example, is not willing to take the vaccine or exercise other measures necessary to contain the virus, that could present a direct threat to the employer. But we're going to talk a little bit more later about what direct threat means in terms of keeping the employee employed or potentially terminating an employee who does present a direct threat in the workplace. If we don't have any questions, we'll go to the next slide. Now, proof of vaccination. So an employer
I'm
can
sorry.
require.
Nancy had a question. I couldn't unmute myself in time.
Oh, okay. Let's hear the question.
I wanted to be sure I understood. I think I heard that if they refuse the vaccine and yet they take other precautions, that does not preclude or constitute a duration of risk or any of these imminent threats. Is that correct?
No, it's sort of correct, but it's sort of not correct. So if an employer does an assessment and finds that an employee who refuses to get vaccinated will present a direct threat, there are other ways to go about dealing with that employee. Now, some employers may be able to accommodate that employee, some may not. For example, you may have an employee that is required to be at the workplace because they cannot do their job remotely. If that employee is presenting a direct threat, the employer at that point in time has to determine whether that employee can still be employed or whether there's other accommodations. For example, the mask wearing, maybe being in a separate office, working off hours. We're going to talk a little bit about that, but the presence of the direct threat, Nancy, does not necessarily mean that the employee will be accommodated or that the employee will be terminated.
Thank you.
Okay. So we're talking now about proof of vaccination. So again, the employer can require the vaccination, and an employee may say that they got vaccinated, but the employer is entitled to see proof that there was actually vaccination. Now, I'm not sure exactly what form that proof is going to be in. For those who have been vaccinated or who have already gotten one dose, perhaps there's some paperwork that accompanies that vaccination, but the employers will be able to require proof of vaccination. If anybody has been vaccinated and knows whether there's paperwork that accompanies that, I would be interested in knowing about that. Now, for an employee who has refused to be vaccinated, the employer is entitled to ask the employee why they have refused to be vaccinated. And this is where the employee's response may elicit some information about an employee's medical condition, making them subject to the requirements for disability-related inquiries under the Americans with Disabilities Act. Now, just so everyone understands, we're just going to take a little detour for a moment. The Americans with Disabilities Act is the law that requires employers to allow employees who have a disability to continue to work if they can be reasonably accommodated. And this basically means that they can perform the essential functions of their job with an accommodation from the employer, but the employer and the employee have to agree to the accommodation. So this specific issue is whether or not the employee has some sort of disability related or other medical condition that renders them unable to be vaccinated. For example, employees who may have severe allergies to the ingredients in the vaccination may not be able to be vaccinated. Whether that employee has a disability or not, I'm not sure. It depends on further inquiry, which the employer is entitled to make in order to accommodate the employee. Another employee who is either pregnant or breastfeeding may refuse to get vaccinated because, quite frankly, there's not enough information out there right now. And I'm not even sure that there is guidance that says that pregnant women are safe to be vaccinated. As a matter of fact, I read an article yesterday in the newspaper, and it specifically said that the CDC and the NIH, the National Institute of Health, are not providing enough information for women who are pregnant or breastfeeding to be able to make that decision. So the point is that if an employer requires proof of vaccination and the employee cannot provide it and explain why they have not been and the employee explains why they have not been vaccinated, this may create other issues that the employer has to deal with regarding medical conditions and accommodating those, or disabilities and accommodating those. Did we have questions, Allison?
No. Nancy, do you want to say what you put in the box or no? Okay, nope, no questions.
Did anybody respond as to whether there was paperwork that they can provide in connection with proof of vaccination?
Yes, that was my comment. I'm sorry. I didn't want to
No,
take your
thank you, Nancy. Thank you,
Yes,
Nancy.
the healthcare district filled out a card for me, put the date, the exact vaccine I had on that date and the time of day. And they followed up since with text things I have to fill out every week to say, am I dying from it or not? When I get my second one, they will complete that card, and that will be my proof in case I want to take it when I go to clients or whatever, if they require it.
Excellent. You see, thank you, Nancy. We appreciate that. I didn't have that knowledge, so I'm going to give you credit for part of this presentation, okay?
No, that just means I'm old. I got the vaccine.
Okay, let's move to the next slide then. So as with everything, there's always some exceptions. We talked a little bit about disability being an exception, but there's also an exception for sincerely held religious beliefs. People with certain disabilities and people with sincerely held religious beliefs may be precluded from being vaccinated. They may be exempted from the vaccination requirement. Now, if that happens, and we're going to talk about this in a second, the employer is going to figure out how to accommodate those people if possible. Now, if the employer determines that that employee, regardless of accommodation, is presenting a direct threat, that's where we get back to the decision of termination or other accommodation. Now, we had mentioned before that accommodations that may be provided, including, the continued mask wearing, the continued working from home, wearing all other types of protective equipment at other times, providing a separate space for the employee to work. Those are not givens, because any reasonable accommodation needs to be weighed against what's called undue hardship to the employer's business. And undue hardship is not necessarily a financial imposition on the employer's business. It could also mean disrupting the flow of the employer's business. So it's not always a financial inquiry, it's other factors that may be considered in what is an undue hardship. And not every employer has the same needs, in which case not every employer can establish undue hardship the same way. So undue hardship can mean different things to different employers. And another thing to remember is that this process of reasonable accommodation has to be something that's agreed upon between the employer and the employee. And we're going to talk a little bit about that on the next slide. Did we have a question, Allison? I just saw something flash.
Yes. Tom Straley wants to know, can you require masking and other safety procedures even after everyone is vaccinated, since transmission may still be possible?
Yes, you can. You remember, this is still the employer has the right to require certain things in the workplace. For example, a dress code. There are certain things that the employer has the right to do, and continued mask wearing, even after the vaccine, is absolutely appropriate if the employer chooses to impose that on its employees. Hand washing, sanitation statements, sanitation stations, even gloves may be required. That was a good question. Let's go to the next slide. So with a disability, I had mentioned that there has to be an interactive process to determine what is a reasonable accommodation, which means basically the employer and the employee get together, they talk about the nature of the employee's disability, they talk about the essential functions of the employee's job, they figure out what the employer can do to help the employee be able to perform the essential functions of that person's job, what accommodation can be provided, and whether that accommodation is reasonable or will present an undue hardship to the employer. It's important to remember that the accommodation is not necessarily what the employee wants. It's not necessarily what the employee's physician recommends. It's what the employer and the employee together decide is reasonable under the circumstances. And again, we come back to the issue of if there cannot be an accommodation, whether the unvaccinated individuals will pose a direct threat to themselves or others in the workplace. And that's going to be a continued theme that we're going to be talking about when we're talking about persons who refuse the vaccination or who, because of other reasons, are unable or unwilling to be vaccinated. Do we have any questions, or can we move to the next slide? Okay, the next slide. So we talked about the disability exception, and now we're going to talk about the religious exception. The reason that those two are specifically singled out is because religion and disability are two categories of protected classes under the law. And when we say protected classes, for example, we talk about protecting someone against discrimination because of their age, their race, their disability, their gender. Religion and disability factor into the specific topic that we're talking about with respect to the vaccination. So if someone is saying that their religion precludes them from having, from taking the vaccine, this actually the first sentence of this I just realized is wrong. It should be employers. Employers should assume that an employee's request for a religious accommodation is based on a sincerely held religious belief. So if somebody comes to you as the employer and says that their religion precludes them from having the vaccine, the employer is entitled to question the religious nature or the sincerity of a particular belief, practice, or observance. Now, this is not a situation where someone may use religion in order to be excused from taking the vaccine. There's other reasons why people may want to be excused from taking the vaccine that we're going to be talking about in a little while. But a religious exception is based on a sincerely held religious belief, and the employer is entitled to ask questions to test whether that really is a sincere belief, if this is sincerely what the religion requires. Normally, this is a very, very touchy subject, but if somebody asserts that their religion precludes them from doing something, you are entitled to ask the questions. And again, we come to, if the employer determines that the employee does have a sincerely held religious belief, employers are obligated to provide a reasonable accommodation as long as this does not present the undue hardship on the employer. And again, we need to go to the direct threat assessment if the employer determines that the employee cannot be accommodated. Any questions?
No.
Okay, we can go to the next slide. So when we talk about I'm sorry, I lost my place for a second. When we talk about accommodations, again, these accommodations are something that the employer and the employee agree to, and they may include the employee working from home or wearing additional protective equipment, providing a separate space for them to work, maybe a separate entrance for them if they're entering the building. There's lots of different ways that the employer can try to accommodate the employee. Let's go to the next slide. Again, the accommodations have to be reasonable and not pose an undue hardship on the employer's business. For example, it is not reasonable for an employee whose job cannot be performed remotely to work from home. For example, a restaurant employee, a retail employee, those employees cannot work from home. So if those employees refuse to take the vaccine, it may be very difficult, if not impossible, for the employer to accommodate that employee if they determine that not taking the vaccine poses a direct threat to others in the workplace. Let's go to the next slide. Now, this is something that I'm sure is going to be coming up, which is what happens when an employee refuses a vaccination for other reasons. So we talked about refusing a vaccine for religious reasons or for disability reasons, because religion and disability are protected classifications under the law, and the employer has to try to work with those employees who have a disability or have a sincerely held religious belief to try to accommodate them, to allow them to work and perform the essential functions of their job. Now, it may not be possible, but the employer is required to explore those accommodations. You have other employees who may refuse the vaccination for other reasons. For example, they're afraid, they don't want to take the vaccine, they don't believe in vaccines, they are concerned that people that have been vaccinated have gotten sick. There's going to be any number of reasons. I know personally people that are against vaccines, generally speaking, and their position is they're not going to take the vaccine, and they're just going to hope everybody else takes the vaccine so that herd immunity is going to be established. Now, that's their belief. That is not a protected belief under the law, but that's their belief. In those situations, an employer should be careful. The employer should try to explore whether this employee can be accommodated. Even though it's not required under the law, the employer should try to explore whether accommodations are possible, because the employer may not want to lose this employee. Now, not every employee is going to be able to be accommodated, but if an employee comes forward and refuses to take the vaccine for reasons that are not protected under the law, an accommodation should still be explored if at all possible. And I think we're going to be seeing more and more of those types of situations, because I do believe that there are people that do not want to take the vaccine, that have a fear of it, and they are just against vaccines. Do we have any questions?
Nope.
Okay, we can go to the next slide. So what do we do if an accommodation is not possible? Well, again, we've talked about this. If an accommodation is not possible, or if the accommodation is such that it cannot substantially reduce the risk of infections to others, the employer must be able to demonstrate that that employee poses a direct threat to the safety and health of other individuals in the workplace. And I think you all have kind of by now understand that while the employer has the obligation to try to accommodate the employee, sometimes it may not be possible. And if that is the situation, and the employer has determined that that employee is going to pose a direct threat in the workplace to other individuals, and you have to remember that there's going to be other employees that are not going to want that employee who has not been vaccinated in the workplace. If that employer has made that determination, then what's the next step? Let's go to the next slide. Okay, termination. So the first bullet point, even if you can fire an employee who refuses to get vaccinated, that does not mean you should. Remember, employees may have different reasons for not getting the vaccinated. We've talked about them: personal preference, fear of the vaccine. So in that situation, you're dealing again with a valuable, an employee who may be able to continue to work remotely. They may be able to have their job duties modified. There may be other solutions. Every case is going to have to be assessed on an individual basis. There is no clear, bright line. So if you have that situation where you have an employee who refuses to get vaccinated or cannot get vaccinated because of a disability or because of a religious belief, you have tried to accommodate that employee. You've made the direct threat assessment. You may be in a situation where you have no other choice but to terminate that employee. When you get to that situation, my advice to you is take a deep breath, step back from the situation, and evaluate whether or not there may be other legal issues that are implicated in the termination situation. Like I said, I think that there's probably going to be a lot of situations where you've got employees that don't have a protected classification, but just don't want to take the vaccine. And if they don't want to take the vaccine and the employer can accommodate them and has determined that they may be a direct threat to the workplace, the employer may still decide that they want to keep that employee, or they may decide that they want to terminate that employee. But any decision as to termination should be probably run by legal counsel, just to make sure that there are no other laws that are being implicated at the time. For example, let's say you've got a situation where the employee has a pending workers' compensation case, or that employee has a harassment case, or the employee has complained about something that the employer has done that they believe is a violation of the law. That employee, if you terminate that employee, may have a claim for retaliation based on that termination, wholly unrelated to the vaccination process. They may claim that they are being terminated because of their workers' comp claim, or because of their harassment claim, or because they are a whistleblower. So I will tell you unequivocally that employers never believe that they are rightfully terminated. They always believe that they are wrongfully terminated, and they are always looking for a way to sue their employer. So all I'm saying is, if you're going to make that termination decision in this context, be careful to look at all the other factors that may implicate that decision, that may complicate that decision. And if you need to, you should consult with an attorney. Do we have any questions, or can I move to the next slide?
Move on. Yep.
Okay. So I think I've pretty much already covered this one because I said everything I needed to say about termination. So we can move on to the next slide, which is a bonus. I didn't even tell you guys that you were going to learn about this today. So congratulations for being on this Zoom call today, because we're going to talk a little bit about the Families First Coronavirus Response Act. And that actually was the subject of another seminar that I did for the chamber way back when, after this law was first enacted. And for those of you who may not be familiar with the law, this law, among other things, but relevant for our discussion here today, is the law that provided the emergency sick leave, 10 days of emergency sick leave that was paid. And this is applicable to employers with less than 500 employees. This is also the law that allowed for paid family leave for childcare up to 12 weeks. So this was a very employee-friendly law. Now, those protections that the FFCRA provided expired on December 31st, 2020. However, under the Consolidated Appropriations Act, which was just signed at the end of December, an employer who provides these benefits through March 31st, 2021 is entitled to a tax credit. Now, the tax credit was allowed under 2020, but an employer can continue to take that tax credit through March 31st, 2021. If, for example, the employer allows paid sick leave or allows paid family leave. And the only caution that I have to this is if an employee has already used these benefits, they don't get a new bank of benefits. So if they use these benefits up in 2020, they don't get new benefits in 2021. So it's not an entitlement, but the employer may provide that. The start date of the FFCRA, which I think is just a question, was April 1st, 2020. Any questions? Any other questions, or can we go to the next slide?
No questions.
Okay. So as I said, employers are not required to provide this leave, but may do so voluntarily. But again, if leave was already provided to an employee, for example, they've used emergency sick leave, they used 10 days of emergency sick leave in 2020, they don't get another 10 days in 2021. But if an employee used only 5 of those sick days and needs to use another 5 of those sick days, and remember, there's specific requirements for use of the sick days. It's not just because you're calling in sick. There has to be specific reasons, which I'm happy to share, after this webinar to anyone who's interested in learning about those reasons. There's a very brief, very concise fact sheet on this that's helpful to see the reasons that emergency sick leave or family leave paid are entitled. But if an employee has used 5 days and needs to use additional sick leave for one of the enumerated reasons under the FFCRA, the employer may choose to allow that employee to use those unused days. So again, the qualifying reasons for which either family leave or emergency sick leave have not changed. The cap on the amount of pay that they have not that they are entitled to receive have not changed. Documentation requirements have not changed, and the total amount of leave has not changed. So it hasn't changed. It's only a voluntary statute if the employer chooses to allow these benefits to continue. If we don't have any questions, we can go to the next slide. So in a nutshell, and this is just a recap of the FFCRA, the employers under 500 employees may choose to provide the leave and seek the payroll tax credit. And again, the extension does not entitle employees to new benefits if they've already used their benefits in 2020. Next slide. So my closing advice is twofold. First, as to vaccine, I think employers should encourage employees to take the vaccine voluntarily rather than mandating it. But employers are entitled to mandate it. So don't be left with the impression that employers do not have that right, because the name of the seminar was, can employers require employees to get the COVID-19 vaccine? And the answer is yes. Employers, in order to encourage employees to get the vaccine, may choose to give incentives to employees that decide to get the vaccine to promote that voluntary compliance. It may be something as simple as an additional paid day off, or maybe, you know, a Starbucks gift card. Whatever the employer needs to do to incentivize employees to get the vaccine. And I always tell employers that they should model the behaviors that they seek to have their employees emulate. So that's my advice for employers as to vaccines. As to the FFCRA, I encourage employers to proceed as they deem is in the best interest of the organization. And not for nothing, those tax credits are valuable to employers. Employers need to understand they're not required to do this. This is totally voluntary. So if they decide to do this, they do get that tax credit. So that's a plus for everybody. And that's basically all I have today. If we have any questions, I am happy to take any questions beyond whatever has been asked. Can employers use FFCRA if an employee gets sick in 20? I'm sorry, I didn't understand the question.
I know because I can't type. It's
Okay.
if somebody gets sick now,
Mhm.
since it was extended to March 31st, if somebody gets sick now, does that FFCRA rule still apply for employers in 2021, February 1st through March 31st?
It only applies. Okay, there's a few things. First of all, if they haven't used all their sick days in 2020, that's number one. Number two, if it's an enumerated reason under the FFCRA that allows that sick leave. And number three, if the employer says that they will allow them to do it.
Okay.
Everything depends on what the employer says, because they may have those days available, Nancy, and they may have an enumerated reason. But if the employer says that law has expired and I'm not required to do it and I'm not going to do it, then that's the end of the story. Any other questions? Allison?
I didn't have a question, but
Hi,
I did have,
Penny.
hi, nice to see you. I was on mute when I was saying, hi, Ellen. I'm sorry about that, right in the beginning. One of the things that I've talked to employers that are my clients about is that they get little pin kind of things that say I've been vaccinated with the logo of the company, if they're dealing with the public especially, because I think that would be a good thing. It's just a little thing that I've said to my clients might not be a bad idea to do. Like one of my companies has a lot of yacht sales offices, and they deal with the public. They go to the boat shows, and they're requiring their employees to get the vaccination as soon as they possibly can. And so I said, why don't you issue these? And, you know, when they show their proof, just as you mentioned the proof, and Nancy said, yes, there's proof. So I've suggested that. Just a thought, just wanted to share that thought.
I think that's great. I think that's great. That's a good idea. Any other questions or comments or thoughts?
I thought this was extremely helpful.
Well, thank you, Penny.
I really enjoyed it. I was looking forward to it and I enjoyed it. It was really
well. I think that you know, this is something that I think that as the vaccine becomes more available,
yeah.
We're going to see what this does in the workplace.
Yeah.
And I think that it's going to enlighten a lot of employers about their employees. And I think that there's going to be a lot of legal issues because not everybody wants to take the vaccine.
Yeah.
And there's some people that just are very sincerely against it.
Yeah, well, I've already had clients asking me regarding employees that say they have health issues that preclude them. And in some cases, we know it's legitimate. In other cases, we don't. So this has been very helpful to say, well, what do you do when that happens? You know?
Right,
Yeah.
right,
Thank
right.
you. Thank you.
Thanks so much. Thanks so much, Penny. Thanks so much, everybody. Hey, Sarah, I like your blonde hair.
Oh, thank you. Thank you. I'm trying to cover the gray, so I'm just making it blonde now. So it
I don't even
blends
know
in.
what color my hair is.
It's funny. First of all, you're awesome. You always are awesome. You really explain things in a way that, we can understand. Legalese is not ever my, I can't ever understand that. And certainly when it comes to employment law, it's terrifying. So thank you very much. Always a great teacher and very, very knowledgeable. I have a question about a particular bill that's been introduced up in Tallahassee to protect employers from frivolous lawsuits, that an employee would sue their employer should they get COVID or a customer. Are you following that bill, and what are your thoughts about it?
Well, it's really interesting because, I've heard about this. But, my feelings on it are, it's impossible to know where an employee contracts the disease because I don't believe that we are doing a whole lot of contact tracing. So unless there is unequivocal proof that the employee contracted coronavirus in the employer's workplace, I don't even think that there's going to be a valid lawsuit. Now, that doesn't mean that employees are not going to try to sue,
Right.
because like I said, people are always looking for something to sue about, especially, employers. But I can't see that lawsuit really going anywhere. And I know that the workers' comp people are all saying, we're not going to cover that if an employee gets, COVID. And if the workers' comp people are saying that, and you have to remember something, an employer can only be sued for something other than like an injury that occurs in the workplace. The only way that the employer can actually be sued and it's not covered under, workers' comp is if there is gross negligence.
Right.
I think it's going to be a really high standard. So I cannot imagine that any suit would be successful. I don't know the status of the law in Tallahassee, but I cannot imagine that any lawsuit would be successful unless you can unequivocally prove that the disease was contracted by the employer, and in the exercise of gross negligence, the employer is responsible as opposed to workers' comp.
Awesome. Thank you.
My pleasure. Any other questions? Well, thank you all. It's been my pleasure. I'm always happy to speak to the chamber people and see my old friends, my friends that are not old, but my friends that I've known for a long time. So I hope you all have a great weekend, and thank you again for attending.
Thank
Thanks,
you, Ellen.
Ellen. We appreciate it. Thank you to everybody for being here. We hope you have a wonderful day, and keep checking the Chamber's website for more events and programs like this and the emails that you get, and enjoy your weekend. Thanks, everybody.
Thank you,
Bye.
Ellen.